the F clause, because that's the only natural corollary. I mean, it doesn't make sense otherwise.
Yes, my lord. And again,
Would there be any incident coming out of F which will go out of H?
my lord, the
मतलब आपने नई केस बनाया, सपोज मिस डिक्लेरेशन हुई, उसके खिलाफ किसी ने कोई क्रिमिनल केस ही नहीं किया, अगर हो जाता तो 2 साल वो होता और फिर उसके बाद 5 साल होता, यही है ना? Is there any situation in F which would go outside H?
my lord, not that I can think of. No.
Do you think the words in F, it says, it doesn't end by a country by a court, it says court of law.
My lord, yes.
Is a court of law different from a constitutional court? Because it could have stopped at the word court. So I just want to know, does it, the of law add anything or doesn't add anything?
My lord, of law adds in the sense that probably the returning officer will not have this power.
The returning officer is not a court. I'm just thinking in terms of Section 9 courts under the CPC. Are these court of law Section 9 courts or court of law, because it should have said, it could have ended by saying by any court.
My lord, over here,
Are we distinguishing between the constitutional court and a civil court of competent jurisdiction, or we are not? It's meaningless, irrelevant.
this honorable court and your lordship yourself have held that over here the word court of law means a court of plenary jurisdiction. In Panama 1, which was not subsequently followed in Panama 3, this honorable court...
What do you mean by Panama 1 and
Panama 1, my lord, was the first case which was decided 3-2, and Mr. Justice Ijaz Afzal Khan, writing for the majority, said that court over here means a court of plenary jurisdiction.
Meaning Section 9 court.
Section 9 court, a court which will take evidence, which will examine the issues where a trial takes place.
Or it could be civil or criminal.
He doesn't make that distinction. And I would submit that if your lordship have to...
Then how did that view change?
Without mentioning what they have done in Panama 2 and Panama 3,
Is it referred to Panama 1 and Panama 2 and 3, this aspect?
no, my lord. Your lordship notices that in your lordship's judgment in Sheikh Rashid's case.
Actually, that was not a judgment, it raised a number of questions.
Yes, it raised a number of questions.
Yes.
But your lordship will see that even after Samiullah Baloch, different tests have been applied. The author judge of Samiullah Baloch was also the Chief Justice of Pakistan in Faisal Wabda's case, and has taken a different view without any reference to Samiullah Baloch.
Where is that view?
My lord, that is reported.
Repentance was that he did not contest the election, so there was a repentance.
My lord, that is Muhammad Faisal Wabda versus Election Commission of Pakistan and others.
PLD kya?
My lord, this is 2023 SCMR 370. My lord, 370. My lord, I have put these cases together in a bundle for ease of reference of your lordship. And this would...
देखिए और भी
Sir,
मैंने कहा और पैसे जाया करवाए आपके
सर ये आपके जो 62(1)(f पे जजमेंट्स हैं,
ये पहले बताएं ये वाला केस
ये सर, it is the last tab, it is tab 20.
you're a member of this.
Yes.
My lord is one of the members.
Yes, his lordship is one of the members.
Said it as if it was something wrong.
Can you read the relevant portion?
My lord, yes, paragraph 4, it's a 2-page judgment really. Paragraph 4, page 373. The petitioner states before the court that he regrets his claim of renunciation of the US nationality at the time of filing his nomination papers for the election of NA 249 Karachi on 7/6/2018. He further states he had then initiated a process for such renunciation, but the certificate of loss of nationality of the US was issued to him on 25th June 2018. He admitted that he was disqualified from contesting the election under Article 61(3)(1)(c) of the Constitution on the date when he had filed his nomination papers for the election of NA 249 Karachi, and that his affidavit filed in with the nomination paper thus contained an erroneous statement which he regrets in order to demonstrate his good faith in remorse for his mistake, he undertakes that he will resign from the office of the member of the Senate to which he was elected. In view of the said statement and undertaking of the petitioner, we are of the opinion that we need not proceed further in the matter in the peculiar facts and circumstances of the case. And if your lordship may see the last sentence, which is the last 3 lines, it is clarified that the petitioner shall not be considered disqualified in any subsequent election on the basis of the instant.
The repentance is that period, that particular election.
Yes.
And so, but this is after he enjoyed the full tenure of the Senate.
Yes. Yes, and then he resigned. He resigned.
But एक चीज देखिए, समूला बलोच में paragraph 6 में the concept of repentance is mentioned.
Yes, my lord.
But I don't find a finding on it then.
No, there is
Argument of counsel finds mention on repentance.
My lord, yes.
But then it is, though the judgment talks about Islamic injunctions, this concept is not discussed unless I've missed it.
No, it is not discussed, my lord. That judgment is also on tab 7 of this very bundle.
So are you repentant?
So, Mr. Makhdoom, we could look at it like this, you see.
Are you repentant or you claim you've done no wrong?
My lord,
At the moment you can only be repentant because your case is over.
my case is over, yes.
I presume you are repentant.
So one reconciliation.
Reluctantly repentant.
My lord, his case was that I made no misdeclaration.
वो तो बात खत्म
My
हो गई
children
ना।
had declared
वो
it
तो हम रिव्यू
as
करने
their
में बैठ
property.
जाएंगे। वो तो फिर हम रिव्यू करने बैठ
ठीक है,
जाएंगे जजमेंट।
So one reconciliation of 62(1)(f) with H could be that if there is a misdemeanor of misdeclaration and no case, criminal case is made out, then he just misses out on the election and the matter comes to an end. But if you want to take it further and you file a case against him which is criminal, then H kicks in and you go through a conviction and 5 years. So there's a 7-year period there and there's an election period here. Because why didn't you not book him in any criminal case? Because you could do that. For any misdemeanor, you could have done that. If you don't let him go and you don't take criminal proceedings, then there has to be some mechanism, because if you take criminal proceedings, the mechanism is 7 years. But if you do not take criminal proceedings, then there must be some way out also. Because it's short of that, because nobody bothered to take the person on for that misdemeanor. So, I mean, that's one.
Mr. Makhdoom Ali Khan, but I think, can we go back to Faisal Wavda's case, please?
My lord, yes.
You said Samula is not mentioned. Samula is mentioned there.
It's mentioned.
ये जरा उससे पहला वाला पढ़ दें, therefore.
बिल्कुल पैराग्राफ में mentioned है. It's mentioned but not followed because Islamabad.
Just पढ़ दें जरा सा. Therefore, it was concluded.
My lord, उससे अगर जरा ऊपर आप देख लें, the Islamabad High Court found that the petitioner was disqualified pursuant to the case reported as Speaker National Assembly of Pakistan versus Habib Akram for submitting a false affidavit. Hence, no declaration was required. Therefore, it was concluded that the consequences given in case reported as Samiullah Baloch and others versus Abdul Karim Noshirwani would follow by finding that a formal declaration by a court of law was not required to disqualify the petitioner under Article 62(1)(f) of the Constitution. The impugned judgment has in its para 11, 12 and 13 therefore misconstrued both Habib Akram and the Samiullah Baloch case. So they say it's been misconstrued and resultantly the impugned judgment is legally not sustainable.
How do you reconcile the two? This judgment and Samiullah Baloch?
My lord, if Samiullah Baloch was...
No, how do you reconcile the same two judgments by the learned same judge?
My lord, my submission is that if Samiullah Baloch was strictly followed, there was no way out but to disqualify Mr. Faisal Wavda and Islamabad High Court.
खबरों का सिलसिला आगे बढ़ाएंगे। शुजाबाद की बस्ती